Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome back, everybody, to another episode of Men's Divorce Podcast. My name is Marcie Patton-Coffman. I am a senior litigation partner with Cordell Law, and I am here today with one of my most favorite people, Tomekia Lee-Chaney from one of our Texas offices. It's Dallas, right?
It's Dallas. That's correct. Yep.
All right. But Tomekia, if you want to go ahead and introduce yourselves to everybody, and then we'll get started on what we're going to be talking about today.
All right. Sounds good. Hey, Marcie. So I'm happy to be here. Thanks for everyone who's joined in to listen. I am Tomekia Lee-Chaney, and I am a litigation partner in our Dallas office. I'm board certified to practice family law, and I've practiced for 19 and a half years. And so I'm excited and I'm ready to go.
All right. Well, then let's go ahead and get started. Today's topic is, I am divorced. Now what? Post-divorce actions. So first, let's start talking about what are parties supposed to do right after their divorce is finalized. What's the first thing that you tell your client when that little timestamp paper comes in the mail, or however you get it? What's the first thing you tell your client?
Great question. So similar to starting a divorce where there's a lot of emotions, a lot of adrenaline, right? Depending on who you are. A lot of times when you're finalizing a divorce, the emotions are somewhat similar. And so it's hard for some people to review that divorce decree. They kind of just toss it away or whatever the case may be. I instruct my clients to review that final divorce decree in much needed detail. It is imperative to make sure that you understand all of the terms in that final divorce decree, because the last thing you would want is for your spouse, former spouse, to now be saying you violated the terms of the divorce decree because you've not met this deadline or that deadline. And so it's imperative to make sure that you read that final divorce decree.
When you say deadlines, what kind of deadlines should our viewers be looking for if they're looking at their final divorce decree?
Great question. So it depends on whether or not you have children or if you're just talking about property and debt division. If there are children, then there are deadlines as it relates to specifics regarding who picks up, who drops off, and those times in which the children are picked up and dropped off. There's also questions about what location are the exchanges to occur. And then you have to consider the school calendars. So there are school calendars that exist, and it may conflict with a date or a time for your possession schedule. So it's important to make sure that you understand those provisions specifically as it relates to the children and those deadlines that may arise as it relates to the children, including support, whether it's your spouse, former spouse that's paying you the support, or whether you're paying them support. You want to make sure that you know the deadlines and how those payments are to be submitted and who those payments are to be submitted to. And then also as it relates to just property and debt division, you want to make sure that you meet the deadlines as it relates to when to exchange personal property, where to exchange the personal property, the date to transfer funds from certain accounts. So those documents in terms of the deadlines and that decree is imperative to make sure that you understand all those details and they are highlighted so that you can refer back to it easily in the event something comes up.
I want to touch on child support here just shortly, because I often find here in Ohio that there is a lag, all right, from the date that the decree of divorce is issued to the date that the child support enforcement agency might start automatically taking the payments out of your client's paycheck. But the divorce decree will say that your child support payments are effective on this date, right? So what do you tell your clients to do in those circumstances?
So it depends on the circumstances as it relates to each individual client. So there are some cases that are high contentious cases. And in those cases, it's difficult because if I instruct my client to pay that person directly, that person may not receive credit for the payment because the relationship is just not one where the parties communicate and cooperate. And so the former spouse may not sign a document needed to make sure that my client receives credit. In those cases, I instruct my client to either do one or two things. You need to submit your payments directly to the child support office and just make sure you document the court cause number and the names in terms of who's to receive payment, so that at least they have that money there waiting once the account is established and the state is ready to send the money. In the alternative, I instruct my client, if for some reason you don't want to send that money to the state because there is no account that's been set up and it's just going to sit out in the atmosphere for some time period, hold that monies, and then as soon as the account is set up, make sure that you send it all at the same time before, at least in Texas, there's a 30-day window that you have to be able to submit that payment and it posts to the child support account. So just make sure you send all that monies in at the same time as soon as that account is set up.
Yeah, and I agree. And I typically advise my clients to do one of those last things that you said, either hold the money in escrow or pay directly to the child support enforcement agency. I almost always advise do not directly pay, because here in Ohio, if you direct pay to the receiving party, it's considered a gift. And if they're not in agreement and then they're in an agreed entry indicating, yep, he paid this, then that my client's going to look like they're in arrears, right?
Spot on. Yep.
You know,
and it works the same in Texas as well in that situation. Absolutely.
Yeah. So, yep, I 100% fully agree with you there. Touching on some more of the other things that we have to do when the divorce decree is issued. You know, you talked about deadlines, but there's also changes that the parties need to be aware of and consider regarding their financial accounts.
Correct.
You know, other things that might come up that maybe they don't think about when their divorce is finalized. Can you talk about other things that might come up after the divorce is finalized that might not necessarily be indicated in their decree of divorce that we would like parties to be aware of?
Absolutely. I think it's important to update and change any sort of personal contact information on any sort of bills that you may have, joint accounts that you may have, unless your divorce decree orders you to cancel certain accounts. And obviously, if that's the case, just make sure that you meet those time restrictions and you appear at the bank to cancel certain accounts. But other than that, you want to make sure that you update and change all beneficiaries on your life insurance policies. You should not want your former spouse to collect life insurance on your death unless there are minor children involved and your divorce decree says otherwise. You also want to make sure that you update any sort of information related to contact for cell phones. For instance, if you and your spouse are on joint accounts, you want to make sure that your former spouse doesn't have access to see who you're calling and when you're making those calls. And social media. You know, a lot of us are on social media. So if your former spouse has access to your social media account, or they are your friend on social media, and you know that you sometimes post certain things that are probably not the best to post on social media and it can be used against you later, you probably want to block your former spouse. Or maybe that's me. Maybe not block them. Perhaps you should create a new account, right? And you can do whatever you want on that new account, but at least that other account that you have where you do certain things, your former spouse isn't able to view. So just make sure that you protect yourself at all costs in terms of making those changes once your divorce decree is signed.
And maybe keep in mind that maybe just because you aren't friends with your spouse anymore on social media, that other people that you are friends with may still be friends with your spouse. So it might be good just to not post anything that could in the future be used against you in any manner.
Very smart. There you go. Yes, ma'am. Including in-laws. In-laws have access to, yes. That's smart, Marcie.
Yeah, I try. When you're talking about, changing beneficiaries and things, it also brought to my mind making sure that clients change their wills.
Yes.
I know that in our decrees, we always have like an estate section, a testament section of our decrees where we reference, hey, you're no longer going to be able or will be entitled to receive anything intestate from the spouse. But if they don't change their wills, right, and something happens, then all the whatever was indicated in their wills still goes to that spouse, even if they're divorced.
That's correct. Absolutely. So we don't have that specific language in Texas regarding it. I think it's great language, though, and maybe something that should be instituted here. But
I'll send you a copy of mine.
I appreciate it. But I think it's important, as you said, for people to be sure that they are changing any sort of power of attorneys that they have for someone to make decisions. In the event they become ill, you want to make sure you change your living wills and your testaments, any codicils, and any medical directives. Because the reality is, it's almost like a life insurance policy. If your former spouse is the beneficiary of your life insurance policy, I mean, to some degree, that your life is in that person's hand. And so that's the same as it relates to the power of attorneys, living wills, the codicils, and directives. If for some reason something happens to you, your former spouse may be the person to let the medical professional know whether or not to save your life or to do the alternative. So just make sure that you change the beneficiaries on these policies, and you change all of the persons who are to make decisions as it relates to your life moving forward.
No, I agree 100%. Now, we've talked a lot about the financial side of it, but divorce is really, really emotional.
It is.
And it can be very stressful for parties, and they can just have a hard time dealing with those kinds of things. What advice do you give your clients, if any, regarding those kinds of situations?
So, there are always different outlets in terms of people that we talk to. I try to encourage my clients to seek some sort of help from a medical professional, i.e. a counselor or a therapist, an elder in the church, or a family member or a friend, someone that's going to give you sound advice, that will be supportive, that will be able to make sure that they can engage with you and they can check on you to make sure that you're fine. Obviously, your mental health is going to be important. I always tell clients, when you have children specifically, in divorce cases, you need to be your best self for your children. And obviously, that's sometimes hard to do when you're in the thick of a divorce case, especially if it's contentious. So you just want to make sure you're getting the help that you need. And I always tell people, don't be ashamed of getting help. It's normal for people to go out and seek help. You don't need to tell everyone unless you're comfortable doing that, but it's normal for you to go out and seek help and talk to someone else.
No, and I agree with that 100%. It is very common in these situations because there's a lot of emotions, right?
Yes.
They're hard situations, and that it is normal and it is okay. And people should 100% not be ashamed to go talk to somebody about it. They'll probably be better off for it.
Right. Agree.
All right. So let's see. We've talked about some property or finances. We've talked about mental health. If you have a shared parenting plan or whatever custody arrangement, which requires counseling for your children or co-parenting counseling or things like that. There are often deadlines that have to be followed to make sure that you are following through with those provisions as well. So that's another kind of check on the box that the parties need to look for in their final paperwork or in their final decree of divorce or shared parenting or whatever your state calls it.
No, I agree. Can I just add on to that? So just to be clear, a lot of times when you're talking about the children in these parenting plans, you shouldn't count on your former spouse sharing information that you yourself can retrieve, right? And so in Texas, we use what's known as Our Family Wizard or App Close for parties to communicate, upload information about the children, so on and so forth. Well, that's not always ordered or mandated. And so in those instances where it's not, it's important to make sure that you reach out to the school officials, and your name is on all contact information. You want to make sure you reach out to all of the medical professionals to make sure that you're updated in terms of any sort of scheduling for the children, or you yourself schedule appointments for the children. But you just want to make sure that you're in the know. Same thing with extracurricular activities. You want to make sure that you are on a calendar specifying each of the days the children are to attend the activities, when they are to practice. Like, all these things are going to be important. And so you don't want to miss those opportunities, because unfortunately, if you do, that gives your former spouse the ability to be able to run back to court and say, oh, they're not following the terms of the order or the decree. And so you just want to make sure that you have all these dates locked into a calendar as a reminder, and don't rely on your former spouse to share that information with you.
And I agree with that 100%. And I, just do the juxtaposed position, right? So if you have not done that, and then later, like, well, I didn't know about this doctor's appointment, I didn't know that this activity was going on, it's not the other, if I'm the other attorney, if I'm on the other side,
Right.
then my question to you is, well, why didn't you take the steps to find out if it was so important to you?
Correct.
Do
Yep.
you not have a phone? Do you not have a computer? Do you not know how to communicate with the school official? Don't ever leave it on the other party to do those things regarding your kid. Take it upon yourself.
Correct.
Make sure that you are signed into whatever school platform that they use, so you can see if your kid's turning in their homework on time, so you can see their grades. Don't rely on the other parent to do that for you.
Correct.
I also often, especially when it comes to parenting and communicating, I like to advise my clients to utilize the BIF method of communication, which there's actually a book on it, in case anybody doesn't read it. It actually might even be called the BIF method. But essentially, communication is brief, informative, friendly, and firm.
Brief, informative, friendly, and firm. I like that. Okay. I will now share that with my clients.
That helps to minimize
the conflict.
Yes.
Yes, ma'am. That's great.
I try. All right. Okay. So let's see what other things come up. Real estate often comes up when we are finalizing a divorce, and those kinds of things happen after the fact. So lots of instances and situations can come up in that respect. So why don't we talk about that a little bit, on what we have to do with real estate once the divorce is finalized?
Sounds great. So now in Texas, the courts aren't allowed or able to order a person to go out and refinance property, right? Because the lenders aren't parties to the lawsuit. And so in those situations, if both parties' names are associated with the mortgage note on that real estate, then it's important for, number one, for the parties to execute a special warranty deed or some form of document deed that's transferring ownership of that property to the spouse who received that property in the divorce decree. That's number one. And then number two, obviously, because the courts can't order a party to refinance the mortgage note on that property, and if that debt remains in your name, you want to make sure that you and your former spouse also execute a deed of trust or secure assumption. And again, that's Texas law, right? And in Texas, what that does is that allows the person whose name remains on that mortgage note that is no longer living in that property and no longer own that property, that gives them the ability to be able to go back to court in the future, if need be, and seek relief, and to some degree foreclose on that property because the former spouse isn't maintaining the payments as court ordered. So it gives you some sort of comfort to be able to say, I understand my name is still on the mortgage note and I'm not living in this property, but I have some form of relief that I can seek from the court in the event something goes awry. So those two documents are definitely needed at the time in which you finalize your divorce, in the event the court awards that property to one spouse over the other one.
And this is why I love having these kinds of conversations, because in Ohio, we absolutely order the person to refinance the house.
Really?
They aren't. Yes, our courts do it all the time. We put it in agreements all the time. And if they fail to do so, sometimes we require that the house be sold. It's kind of like an if and then clause. Okay. And we typically give them a certain amount of time. It's varied over the years, but we'll say between 3 and 9 months to complete that refinance. And if they fail to do the same, and a lot of times the refinance is what they utilize to pay the other party their share of the equity in the house. So, a lot of things are tied into that as far as that goes. But yeah, we absolutely require it. We even put in language, or I'm not going to say all attorneys I know how to do this, but I put in language into my decrees that, because you're talking about having to transfer the deed or doing a quitclaim deed to transfer interest or whatever, I put language into my decrees that indicate that should a party fail to transfer their interest in the property as required by this document or by this order of this court, then this document can serve as the transfer of that property. And I'll put a legal description of the property in there for purposes of the transfer. They can record it with the deed. Or record it with the recorder's office.
See, that's smart. And I can tell you too, like in Texas, so parties often request from the court that one spouse, one of either themselves or their former spouse or spouse at the time be able to keep that property, right? And so we have had cases in which, a lot of cases in which parties have been able to work through that process of one person being able to refinance. And obviously, if the party isn't able to refinance, similar to your situation in Ohio, where the court can order the house to be sold, and someone can request a receiver be appointed, where that person takes control and ownership of the property, and then that person goes out and sells the property. But ultimately, what the courts like to do is, or at least Texas law allows for parties to sign that special warranty deed and a deed of trust and secure assumption that allows the other person to be able to have that somewhat limited protection or comfort to say, I understand the situation and what's happening, especially considering the interest rates on the homes went up over the past couple of years.
Right.
And so because of that, a lot of people are like, I don't necessarily know if I want to sell the house and buy a new one because I have a great interest rate right now, right? And I don't want to go out and get this high interest rate on a new place. So there's a lot of workaround in Texas in terms of that process.
I would just always find it fascinating how different things are from state to state. Like,
Right.
it's a learning. I love learning.
Yes.
Let's talk about taxes.
Oh, yes.
Oh, yeah. Because once you're divorced and you're moving money and you're transferring stock and all kinds of fun things.
Yes.
What do you tell your client in regards to taxes after they completed their divorce?
Great question. I am not a tax attorney. That's what I tell my clients. I cannot give you legal advice as it relates to taxes, but I can definitely refer you to someone who I know who actually is a tax attorney that can advise you appropriately. But I do tell them it's important to make sure that you talk with a tax professional or a financial planner, because things tend to change when your divorce is finalized, right? There's certain assets that you've been awarded. There may be penalties, maybe interest, maybe certain things that you need to pay, and you need to make sure that you get the appropriate advice at the time you finalize your divorce regarding how to handle those particular assets.
And you need to make sure that the right party is paying those taxes on those assets as well, because
Agreed.
Depending on how the language of your decree is, if it's being transferred in a certain way where, it's not a taxable event. If you do it like it be a retirement, be a qualified domestic relations order, or what we refer to as quadros here in Ohio, they're supposed to be transferred in a manner so that it's not a taxable event unless that other person decides to liquidate that retirement asset, right? So
Correct.
there's many different consequences that can go in or that can apply to tax law and how your taxes are going to be impacted and affected, and the differences between filing separately versus filing singly versus filing head of household, making sure that there's a clear understanding of who's claiming the interest on the house for that year prior to the divorce, if you're still in that kind of tax fiscal year or whatever.
Right.
Some things for the parties to think about. But yeah, I think that is great advice. Go talk to a tax attorney, because that's not me.
But I will piggyback on what you said, in terms of the quadros, right? The qualified domestic relations orders. So a lot of times when parties initially come in for a consultation, they assume that in order for their former spouse, to receive monies from their 401k accounts or what have you, that they would need to pull that monies out of the account and pay them that monies when the divorce is finalized. And I instantly say, no. That would require that you're responsible for the taxes, penalties, and early fee withdrawals if you were to pull that monies out. So there is what we prepare, which is called a qualified domestic relations order, that's signed by the judge at the time the judge signs that final divorce decree that specifies how that monies is to be transferred. And that document is then sent to the plan administrator of the retirement company. And that person then removes the monies from the account and puts it into another account in that former spouse name solely. So then if that former spouse wants to pull that monies from the account, then they're responsible for the early withdrawal, taxes, penalties, and fees if it applies in that situation. So that was a great point to bring up in terms of that quadro, that QDRO.
Well, thank you for that.
Absolutely.
All right. Well, we're running out of time here. Is there any final advice that you like to give a clients when their divorce has been officially finalized?
Yes. So my final advice would be just live, love, and laugh. Just do what makes you happy. At the end of the day, grief of a divorce is temporary. There is always a light at the end of the tunnel. So do what makes you happy and keep your family law attorneys phone number on speed dial. Because if for some reason something happens where you need advice, or it's a high conflict issue where your former spouse is not being cooperative, ask your family law attorney to give you advice in terms of what actions you need to take.
I think that is fantastic advice. Thank you so much for taking the time to join me today. And thank everybody for tuning in and watching this podcast. Have a great day.
Thank you. You too.